Bob, what are the types of ways you can give away property in a will?
Well, there are several ways you can give away property in a will. The thing that we're most familiar with is a general bequest. I give you $10,000. I give him $20,000. I give them $30,000. That's called a general bequest. The There is an offshoot of the general bequest called a demonstrative bequest. I give you $10,000 from my Citibank account. I give them $20,000 from my Merrill Lynch account. I give those people $30,000 from an annuity that I may have with MetLife. So that's called a demonstrative bequest. Then you also have a specific bequest. Specific bequests, I always tell my clients, are the type where you say, I give my red Cadillac to John and my blue Volkswagen to Mary. Those are specific bequests. The issue with specific bequests is that the item has to be around when the person passes away. Now, generally, people should make wills when they're on the younger side, and the assets that they have then are probably not the specific assets that they have then are probably not the specific assets they have when they pass away. For all we know, they may have traded in the Cadillac for a Prius or some sort of a hybrid car, and they no longer have the red Cadillac. The people who were supposed to get the red Cadillac don't get anything. They don't get money in lieu of not having a red Cadillac. They don't get another colored car. If the red Cadillac is not around, they just get zero. And then the final type of bequest that a person makes is called a residuary bequest. So in every will, after you stop giving away specific items, 10,000 here, a car there, a piece of jewelry to somebody else, you need a catch-all phrase. That catch-all phrase is called the residuary clause. And typically the residuary clause is everything that's left over after those specific items are given away. Now the residuary clause could be good for a beneficiary if the decedent has a lot of money and hasn't given a lot of stuff away beforehand. Typically a residuary clause may say everything else that I have left over, half to my friend, half to my brother, and that's and they would share in the pot that's left over. The downside, of course, to a residuary clause is there might not be anything left over. The testator may have given everything away above that, 5,000, 10,000, 30,000, 20,000, may have given away all of the assets ahead of that, and the residuary clause could be zero. So you get your 50% of zero is zero. Or the other downside of being in the residuary clause is that most of the time expenses are paid out of it. Attorney's fees, executors' commissions, taxes, any open bills that are, those usually come out of the residuary clause. So that's the downside. So those are the four types of bequests that you generally see in any type of will: a general, a demonstrative, a specific, and a residuary clause.